Hi, everyone. My name is Josh Ray. I'm a London-based partner at Ravelli. I work in the area of white-collar criminal defense, and I represent mainly individuals and corporations here in the UK and in Europe who are facing enforcement actions of one kind or another from the US government. So the purpose of the lecture today is to talk about corruption risk and why there are corruption risks beyond the Foreign Corrupt Practices Act, the Fcpa. And I think this should be particularly relevant to this audience because you're all involved in international businesses, likely many of which involves the U.S. in one way or another, and likely involves some sort of corruption risk. Actually, Tom, can we start over? Sorry. Hi, everyone. Welcome. My name is Josh Ray. I'm a London-based partner at Ravelli. I'm a U.S. lawyer and a UK solicitor, and my practice focuses on defending individuals and corporations based here in the UK or in Europe or the Middle East who are involved in some sort of enforcement action from the US government. The topic of this lecture is going to be corruption risk, and to talk about why it's really much broader than the Fcpa, which is a law I'm sure most of you are aware of. So just to start with a little bit of background on exactly what the Fcpa is. So the Foreign Corrupt Practices Act was a law passed by the U.S. Congress in the 70s in the wake of Watergate, in the wake of congressional investigations that found that some of the biggest U.S. companies, Boeing and Lockheed Martin, and Coca-Cola, and a whole host of big, massive U.S. companies, were really just as a matter of practice bribing governments all over the world to get government contracts. So, for example, Lockheed Martin was going to Pakistan to sell, F-16 fighters, and to get that contract, they were paying off the senior officials in Pakistan to get that. So, the U.S. Congress kind of was looking at that and said that was something they really didn't want to happen anymore, so they passed this law. Now, so kind of for the first 20 years or so that the Fcpa was in existence, there wasn't really a lot of activity from the U.S. government in terms of enforcing the Fcpa. But then that changed in around 2000 when the Department of Justice and the SEC were the two government agencies that are in charge of enforcing the Fcpa. Really started to ramp up their Fcpa investigations and really started to ramp up their enforcement actions against companies. So since 2000, past 20 years or so, I would say the Fcpa is kind of one of the biggest areas of focus for the U.S. government, particularly in terms of going after foreign companies. And it's resulted in there's been numerous people who've gone to jail for Fcpa violations. There's been hundreds and hundreds of fines paid to the government for Fcpa violations. So it's quite a big deal. I'm sure that everyone in this conference has probably at least heard of it, given the nature of your international trade work. But just to give you just kind of a background and overview on exactly what it prohibits and what the elements are. So first things first, it applies to three categories of people. So the first is U.S. issuers. So those are companies who list on a U.S. stock exchange. So obviously that includes U.S. Publicly traded companies who trade on New York Stock Exchange or NASDAQ or one of the other exchanges, but also foreign companies who might list a class of securities on a U.S. exchange. So, for example, there was a case a couple of years ago against a Swedish telecom company that listed 99.9% of its securities on a Swedish exchange, but listed really just a couple hundred shares of ADRs, which are a type of security that foreign companies can use to list on a U.S. exchange. But anyways, so the Swedish company was found to be subject to the FCPA because of these few hundred shares that it had listed on the exchange. So that's category one, U.S. issuers. The second one is domestic concerns, and that includes any company who is incorporated in the United States, or who's otherwise headquartered in the United States. And it also includes U.S. citizens and U.S. residents. And then the third are people who are physically located in the United States while they're taking some activity in furtherance of the scheme to violate the FCPA. So category two includes U.S. citizens, regardless of where in the world they might be operating from. And then category three is kind of the reverse, where it's people from anywhere in the world who are acting from within the United States. So broadly speaking, those are the three categories that apply to. And then the rest of the elements are, if someone from within one of those categories gives anything of value to a foreign official with a corrupt intent. That's what a FCPA violation is. So what does anything of value mean? It really means literally anything of value. And the value can be, we're literally just $1, a cheap bottle of wine, really anything of value. There is no materiality requirement. Now, obviously in practice, the Department of Justice and the SEC really is not going to go after anything, any violations that are based on your super minor things, but they have gone after things that are fairly minor. For example, giving theater tickets, giving tickets to a football game, giving things like that. That's been deemed anything of value. Wine, elaborate dinners, those type of things. So if anything of value is given to a foreign official, oh, and actually I should also mention, it doesn't just include things. It also includes, for example, helping a foreign official's kid get a job at your company, or doing anything like that. We're kind of not necessarily a material item, but it's more kind of a favor done for the foreign official. That also falls within anything of value. Then to a foreign official. So this is another element that has been interpreted extremely broadly by the courts. And so foreign official doesn't just mean an elected official, an official in another country. It also includes extremely low-level officials in government somewhere else. It also includes individuals working at companies that might be owned by foreign governments. So, for example, there was a case a number of years ago that involved the utility company in Haiti that actually was set up as a private company, but it was totally owned by the government. And the top executives at that power company were found to be foreign officials because of the ties with the Haitian government. So this is an extremely broadly interpreted element. And then third, is with a corrupt intent. So just giving something of value to the foreign official doesn't by itself violate the FCPA. It has to be shown that the bribe payer is making that payment to the foreign official for an explicitly kind of corrupt purpose. And what that's interpreted to mean is, you're giving money to the foreign official to induce them to do something contrary to their, official duties, or you're paying them to induce a different official to do the same thing. And overall, the whole purpose of this is to get something of value from a foreign government for your company. So in a nutshell, that's essentially what the FCPA is. Now I should mention that this is just what we just covered. It just talks about the bribery portion of the FCPA. So there is a whole other part of the FCPA law that discusses accounting standards, and kind of how you have to maintain your books and records to ensure that payments are not being made to foreign officials through some sort of slush fund, et cetera. I haven't discussed that, but that is an important part of the law. But I just want to, it's just beyond the scope of today's lecture. But Just note that there is, much more detail to the FCPA than what I've just covered. This is just kind of the broad strokes. So I think the takeaway from this is, one, that the FCPA is extremely broad in terms of how it's been interpreted, and in terms of the types of conduct that it covers and who it covers. But it also is, in a certain sense, quite limited in the sense that it doesn't cover two big categories of parties who might be involved in bribery schemes. And the first is obviously the bribe recipient themselves. So you'll see here, the recipient of the bribe isn't actually targeted by the law itself. So the foreign official couldn't really be prosecuted under an FCPA. And the reason for that is the US government, when they were passing this law, they made a decision that it was probably best to maintain US foreign relations with other governments if the US Department of Justice wasn't going around the world arresting foreign officials for receiving bribe payments from US citizens. So they were kind of omitted from the law. Now, that being said, they can still be targeted with using other US laws. Like there's money laundering laws and other sort of laws. But in terms of strictly the FCPA, they aren't included. It also obviously doesn't include companies with no ties whatsoever to the United States. So if you're a privately held company in Morocco, let's say, for example, and you're paying bribes to a Lebanese official using euros and no sort of connection to a US citizen, no sort of connection to the United States at all, you can't be targeted for the FCPA. So there are kind of two holes in the coverage of the FCPA law. And that brings us to the next topic. And this is a court case that happened in New York last summer called the United States versus NAPOUT. And broadly speaking, the defendants here, it was NAPOUT and the co-defendant. They were both officials at South American football organizations that were affiliated with FIFA, based in Geneva. And essentially what these guys had been doing for a number of years was that every time there was a big FIFA football tournament that was going to be broadcast in South America, all the big media firms down there would kind of compete with each other to get the rights to broadcast those games. And the way that they did that, they would have to go through NAPOUT and his co-defendant. And NAPOUT and his co-defendant were soliciting major bribes from these firms. And so they would kind of take in money. Then they would use their authority at FIFA to ensure that the firms who paid them got the rights to broadcast these FIFA games. And this is kind of the standard practice that they had been using for a while. And then the bribes were quite big, I mean, in the millions of dollars. But as you can see here, so it involved media firms in South America, a defendant, NAPOUT, I think, was based in Paraguay, and his co-defendant was based in Argentina. And then they were kind of, defrauding FIFA a bit, because FIFA, the folks back in Geneva headquarters, well, most of them anyways, weren't aware of this whole bribery scheme happening, and they weren't receiving any bribes. But it didn't, the fraud scheme itself really didn't involve the United States at all. But nevertheless, they were arrested. I think both of them were arrested while they were visiting FIFA in Geneva. They were eventually extradited to the United States from Switzerland. And then they went on trial in federal court in Brooklyn on a 47-count indictment for racketeering, honest services wire fraud, and money laundering. So 47-count indictment is very serious. So this was seen as a very kind of big case, and this was a big deal at the time, not least of which because the United States was kind of sticking its nose into international soccer, which the U.S. otherwise doesn't have much to do with, and I think it ruffled a lot of feathers, particularly definitely here in the UK, and I'm sure elsewhere in the world. But in any event, They went on trial. They were both found guilty. Both received pretty lengthy sentences. I think Napow got 48 months, and the other guy got over 100 months, and then plus huge multi-million-dollar fines. And they both appealed to the Second Circuit Court of Appeals, which is the appeals court in New York, which is just one layer below the Supreme Court and is one of the most important appeals courts in the United States because of where it's located. And so the question on appeal that they raised was essentially, assuming that everything that the government said that they did happened, the defendants argued, well, that still wasn't a violation of US law because we were sitting in South America, the people who paid us bribes were in South America, and the company at issue, FIFA, is based in Switzerland. So why does the US care about this, and why should we have to go to jail in the United States because we were doing this? And the question was whether the honest services wire fraud charges were being used to target, extraterritorial conduct, so conduct outside the United States improperly. And so just briefly, honest services wire fraud, it's a relatively new category of fraud that's been recognized by the Supreme Court within the last couple of decades. And essentially what it prohibits is, in the traditional fraud scenario, the fraudster is telling a lie to the victim in order to get money from the victim based on a false pretense. And that's the standard fraud scenario. In an honest services wire fraud case, it's really more of a bribery type scenario. So it's the fraudster is an employee, and what the employee is doing is receiving a bribe from someone else in order to induce him to breach his duties to his employer to do something that the bribe payer wants him to do. So it's more commercial bribery rather than bribery in the sense of kind of inducing a foreign official to do something. So it's very similar. It's essentially bribery, but in the federal system of the United States, it's targeted as honest services wire fraud. And so the question was, well, where did this honest services wire fraud actually happen in this case? Did it happen just in South America, or did it really happen in the US? And so the way that the court looked at it was they looked at the statute and tried to determine what was the actual statute's focus and where did that occur. And so in the defendant's perspective, they said, well, what the law is actually concerned with is this underlying scheme to the fraud. And from how they viewed it, they said, well, everything relating to the actual fraud happened either in South America or in Europe. So this wasn't US, had nothing to do with the US. US law should apply. The government, on the other hand, the Department of Justice, said, no, the statute's focus is actually the use of US wires. So it's the electronic communications using the wires within the United States. And so that was the debate between the parties. And the Second Circuit ultimately came down on the side of the Department of Justice, and they said, we agree that the real focus of honest services wire fraud isn't actually the fraud itself, but it's just the use of wires in connection with the fraud. And they said, but in order for it not to be an improper extraterritorial application of US law, the use of the US wires must be essential to the overall scheme. And what they pointed to in this case as to why the wires were essential were these factors. And they said, well, even though you were based in South America, the bribe payments were being routed through bank accounts in New York. They also went on a few shopping sprees in Manhattan, kind of just blowing cash that they had just received in bribe payments on jewelry and clothing and other types of things. They also were getting U.S. banknotes, like crisp, stacks of $100 bills, hand delivered to them in Argentina. And they also were storing some of their money in U.S. bank accounts. So the Second Circuit, looking at all that, said, well, the purpose of this overall scheme was to get money, and the way you got that money and the way you spent that money was through the United States in some way. So tough luck, you violated U.S. law. The convictions and the sentences were allowed to stand. So that was the decision. It just happened last year. As far as I'm aware, it hasn't been appealed to the U.S. Supreme Court. Even if it is, it's very unlikely that the U.S. Supreme Court would hear it. So for all intents and purposes, at least as of now, NAPOUT is the law of the land, or at least the law in the Second Circuit, which, because it's located in Manhattan, really drives financial crime law for the whole United States. So it's an important decision. And it has a few implications for businesses, and particularly those businesses that are engaged in cross-border commerce and engaged in commerce in locations where bribery might be more accepted as part of the local culture, or locations where compliance standard for local companies hasn't really caught up to U.S. standards. So the first implication, I think, is that when we're thinking about protecting yourselves from potential bribery charges, or you're thinking about how to prevent your company from potentially running into bribery issues through compliance procedures, is you really have to think beyond just the FCPA, and you really have to think beyond even the UK Bribery Act, which are the two really the main laws that international companies look to. And you really have to consider, your exposure to U.S. law, even if you're not a company that really falls into one of those traditional categories of the FCPA laws. Second, foreign officials and non-U.S. companies can be targeted. So kind of the omissions that the FCPA makes, they can be, kind of corrected now using the honest services wire fraud law, as long as a U.S. wire is an essential part of the scheme. And just, finally, just a takeaway, and this isn't earth-shattering news, but kind of any sort of activity that even, maybe tangentially involves transfers of money to the United States, communications with the United States, even communications with U.S. citizens located outside the United States, or anything involving U.S. dollar transfers, even between two banks outside the United States, can be the trigger for U.S. jurisdiction. So that has to really be considered by international companies. So I think the takeaway from all this is really, the NAPOUT decision is out there now, still relatively new. I think it's important for international companies who could find themselves subject to U.S. law to really kind of make sure that they're incorporating NAPOUT and kind of the most up-to-date wire fraud laws into their compliance procedures and policies, and really just keep this in mind. So anyways, I think I'm out of time. Thanks so much for your attention and your time. Thank you very much. Take care.